The US Supreme Court appears poised to nullify the Voting Rights Act, marking a significant setback for civil rights. The Voting Rights Act, a cornerstone of the civil rights movement, has been under gradual nullification by the Supreme Court for over a decade. The latest threat comes from a case challenging a new congressional districting map in Louisiana, which aims to protect black political power. The Supreme Court's stance on this case could have far-reaching implications for minority voting rights across the nation. The case, Louisiana versus Callais, revolves around a new congressional districting map drawn in Louisiana after the 2020 census. The map initially featured only one majority black congressional district, despite the state's one-third black population. This sparked a lawsuit from voters, leading to federal courts ordering Louisiana to create maps that reflect the racial composition and provide equal opportunities for black voters to elect representatives of their choice. However, a group of non-African American voters pursued to overturn these racially proportionate maps, arguing that enforcing the Voting Rights Act violates their rights under the 14th and 15th Amendments. They claim that the maps designed to address racial discrimination against black people actually discriminate against non-black, primarily white, voters. The Supreme Court seems likely to rule in their favor, which would effectively nullify the Voting Rights Act. This potential ruling aligns with the Supreme Court's previous actions under Chief Justice John Roberts. In 2013's Shelby County v. Holder, the court struck down Section 5 of the Voting Rights Act, which required jurisdictions with a history of racial discrimination to obtain federal pre-clearance for changes to voting laws. Since then, the court has consistently narrowed the conditions for voting rights claims and expanded states' leeway to enact potentially discriminatory voting laws. This shift has led to a significant increase in the racial turnout gap between black and white voters. On Wednesday, the Supreme Court appeared to apply a similar logic to Section 2 of the Voting Rights Act, questioning whether it should still be enforced. Justices Kavanaugh and Alito argued that racial gerrymandering is justified if it serves a partisan purpose, focusing on the lawmaker's intentions rather than the discriminatory impact. This stance contradicts previous Supreme Court precedent, which emphasizes the impact of discrimination over intent. The case reflects the Roberts Court's hostility towards racial justice claims from minorities, and its willingness to distort civil rights law and Reconstruction amendments to entrench historical hierarchies of race and gender. Louisiana's Attorney General, who has switched sides in the case, claimed that assuming black voters would vote differently than white voters is unconstitutional. This argument was met with exasperation from Justice Kagan. The Supreme Court's potential ruling could have severe consequences. If the court sides with the non-African American voters, it would effectively end the Voting Rights Act, dismantling the civil rights movement's crowning achievement. This decision would likely come just months before the 2026 midterm elections, resulting in expected gains for Republicans in the House. The implications are profound, as the court's actions could significantly impact minority voting rights and the democratic process in the United States. The Supreme Court's ruling is expected in June, and the outcome will shape the future of voting rights and civil rights in the country.